This is an overview of the various kinds of protective orders available under California law. Not just those that have to do with family law, but also those that relate to criminal, juvenile, and civil protective orders. And as minors counsel, you may need to be aware of different kinds of protective orders depending upon the circumstances that you're dealing with. The first thing you need to be aware of is what's called an emergency protective order, an EPO. And you can read about that in Family Code sections 6240 et seq. Now, these usually begin with a phone call by law enforcement to the magistrate in the middle of the night. The magistrate is the judge who's handling law enforcement contacts for search warrants and various kinds of urgent things that are brought up any time of day or night, but oftentimes these happen late at night or on weekends. The officer calls and reports that he was called to the scene and tells what he or she observed at the scene and what they were told at the scene, and asks the magistrate for an emergency protective order. So the officer is the one who actually requests the EPO, but then, depending on what the officer tells the judge, it's the magistrate's call whether to actually grant it or not. If the magistrate grants an emergency protective order, it takes precedence over any and all other protective orders in any other case involving these people. Very often, by the time the officers arrived and called the magistrate, the person who's accused of the violence has already fled the scene, though sometimes they've been detained at the scene. In order to get an emergency protective order, there has to be reasonable grounds to believe that there is an immediate and present danger of domestic violence or child abuse or abduction, elder or dependent abuse or stalking, or reasonable grounds to believe there is a demonstrated threat to campus safety, and that the EPO is necessary to prevent the occurrence or recurrence of any of those kinds of abuse. So the grounds that are alleged are going to be the immediate and present danger of domestic violence based upon an allegation of recent abuse or a threat, child abuse by a family or household member based on an allegation of recent abuse or a threat, child abduction by a parent or relative, again based on reasonable belief that the person has the intent to abduct or flee the jurisdiction, or an allegation of a recent threat, elder or dependent adult abuse based on an allegation of recent abuse or threat, but you can't get an EPO only for financial abuse. There has to be alleged the immediate and present danger of one of those things, or of stalking based on the allegation that this person has been willfully, maliciously, and repeatedly following or harassing another person, or has made a credible threat with the intent of placing that person in reasonable fear for his or her safety or the safety of their immediate family. Or in the case of a school protective order, the school or campus peace officer asserts reasonable grounds to believe that there is a demonstrated threat to campus safety if there is a memorandum of understanding in place between the school and the local police jurisdiction. Now, for an EPO based on domestic violence, there has to be a certain kind of relationship that exists between the person who's accused of the abuse and the person who's the alleged victim of the abuse. It has to be a spouse or former spouse, a cohabitant or former cohabitant, a dating or engagement or partner relationship, or a party with whom a person has had a child where the male parent is presumed by law to be the father, or the child of a party or a child subject to a parentage action where the presumption applies, or a person who is related by blood or marriage to the second degree. In other words, parents, grandparents, siblings, children, and their spouses. The people who can be protected by an EPO in the case of a domestic violence situation are the person and the children who are in danger. But notice that the fact that the endangered person has left the household to avoid abuse does not affect the availability of the EPO. So if the person has fled the house in order to avoid the abuse, they can still get an EPO. Orders that are available under an emergency protective order are things like personal conduct orders, which are what we commonly call the no negative contact orders. In other words, do not harass, attack, strike, threaten, those orders. And those orders can protect either the individual or even animals. You can make stay away orders, which require a person to stay a specified distance away from the protected party, or residence exclusion orders, where you can exclude a person from a residence even if he or she owns that residence or is the primary tenant in that residence. Temporary care and control of a child of the endangered party and the restrained party. So if they have a child in common, you can actually give custody to the individual who is the protected party on a temporary basis. And temporary care or control of an endangered child or other children in the family or household with the parent or the guardian of the endangered child. You can get orders for temporary care and control of a child who's in danger of abduction. Welfare and Institutions Code allows for orders to protect elders or dependent adults. You can also get a prohibition on an action to get an address or location of a protected person. In other words, you can't try to find out where they live or their caretakers or their guardians, and unless there's good cause not to make that order, that's an order that's likely to be made. Now, an EPO only has a very short time frame. It will either expire at the earliest of the close of business on the 5th court day after the issuance or the 7th calendar day following the day of issuance. And that means that it's an outside 7 days, but it could be less. For example, if an EPO is granted on the Friday before Thanksgiving, it would expire the following Friday, even though there are only 3 judicial business days in between, Monday, Tuesday, and Wednesday. And Thursday, Thanksgiving Day, and Friday are both court holidays. So even though there are only 3 days that are business days between the issuance and the expiration, that's the outside date. So 5 court days or 7 calendar days maximum. Now, the police will personally serve the respondent if they can locate and they can give a copy to the protected party. Also, the same time the emergency protective order is made, law enforcement is required to enter that EPO into the Department of Justice database so that if law enforcement encounters the restrained person, they can identify that there is a restraining order without having to do more than just look in their computers at the DOJ database. Probably the orders you're going to be most familiar with are Domestic Violence Prevention Act orders found in Family Code sections 6200 et seq. The purpose of the DVPA is to prevent domestic violence and provide for separation for a period of time sufficient to enable the parties to seek a resolution of the causes of the violence. But the court need not believe that there is a possibility of future abuse in order to grant a restraining order. The burden of proof depends upon what kind of an order you're seeking. For example, to get a temporary restraining order under the Domestic Violence Protection Act, you're going to need to show reasonable proof of a past act or acts of abuse. But to get an order after hearing, the burden shifts and it becomes a preponderance of evidence, which is defined in Evidence Code section 115. Now, to renew a restraining order after the original order after hearing expires or at the time that it expires, the burden of proof is still a preponderance of evidence that the protected party still entertains reasonable apprehension of future abuse, and there need be no showing that further abuse has happened since the original order was issued. But there does have to be a reasonable apprehension. Well, what is abuse? Well, it includes things like intentionally or recklessly causing or attempting to cause bodily injury, or sexual assault, or putting a person in reasonable apprehension of imminent serious bodily injury to that person or another, or behavior that has been or could be enjoined under Family Code section 6320. Things like molest, attack, strike, threaten, stalk, sexually assault, batter, credibly impersonate, falsely personate, harass, telephone, including annoying telephone calls, destroying personal property, contacting directly or indirectly or by mail or otherwise, coming within a specified distance, disturbing the peace. Now, some of those may be unfamiliar to you, or you may not know exactly what they involve. So they're defined at various places in the code. Stalking is defined in Penal Code Section 646.9. Credibly impersonating is found in Penal Code Section 528.5. Falsely personating is Penal Code Section 529. Harassing by phone is Penal Code Section 653M. Disturbing the peace is defined in case law. Email hacking, disseminating information from a personal journal, sharing personal information with a family or an employer, things like that. But there has to be a particular kind of relationship that exists between the protected person and the restrained person in a domestic violence case. It's a spouse or former spouse, a cohabitant or a former cohabitant, a person in a dating or engagement relationship, either present or past, a person with whom a person has had a child, where the man or male parent is presumed by the UPA, Parentage Act, to be the parent, or a child of the party, or a child subject to a parentage action, where the presumption applies, or a person related by blood or marriage to the second degree. In other words, parents, grandparents, siblings, children, and the in-laws that are related to those same people. Mother-in-law, father-in-law, grandparents-in-law, brothers and sisters-in-law, and daughters and sons-in-law, things like that. Now, there are some definitions that people are going to play games with. For example, cohabitant. Well, a cohabitant is defined in the case of O'Kane versus Irvine as a person who regularly resides in a household, a part of a social unit. We're not talking about roommates or sublessees, people who have somehow decided to share expenses, something like that. There has to be some kind of a social unit that we're talking about here. People in a dating relationship. Well, what does that mean? Well, it's defined. It's frequent, intimate association characterized by the expectation of affection or sexual involvement independent of financial considerations. So it's not a relationship that exists after one date that is never followed with another date. It's not a relationship that exists between, say, a prostitute and her John. There are other things you need to know about relationships. For example, if there is bad blood between a father and the child's stepfather because the mother is now remarried, the fact that father and stepfather have a common relationship with the child does not mean they have the required relationship with each other. And so father or stepfather can't get a restraining order against the other one of those two, father or stepfather. And for a domestic violence request from a mother that's based upon the father's abuse of the child, you have to ask, the judge has to ask, whether that abuse placed the mother in reasonable apprehension of imminent serious bodily injury to herself or the child or disturbed the mom's peace. So what will happen is this. The child will claim that there's been some kind of abuse, and so mom will file a restraining order naming herself as the protected person against dad. Well, that's where the judge has to look and see, wait, who was the one who was subject to the abuse? Because that's the critical question. Who can be protected by a domestic violence restraining order? Well, the petitioner, obviously, for good cause, other named family or household members. But in the case of a minor, if the minor is age 12 or more, they don't need a guardian ad litem. They can bring their own restraining order, and that's true in the domestic violence area. It's also true in the civil harassment area that we're going to see in a little bit. But can you get mutual restraining orders? Not at all, unless both parties personally appear at court for the hearing, both present written evidence of abuse. In other words, the respondent has to file his or her own request for a domestic violence restraining order, and the court has to make detailed findings of fact that both acted primarily as aggressors, neither acted primarily in self-defense. Well, what kind of restraining orders can you get? Well, there are various kinds. There are personal conduct restraining orders. There are no contact restraining orders. There are stay away orders. There are orders pertaining to pets, determining who's going to provide care for them, stay away from the pets, personal conduct toward a particular animal. There's residence exclusion orders and other restraints that are necessary to effectuate the court's orders. There's an order, for example, that the protected person is protected from having the restrained person seek his or her address. Temporary custody and visitation orders can be made. Orders about parentage that are made by stipulation, subject to a possible set-aside depending upon the way that the facts lay out later on. And orders pertaining to the temporary use, possession of real property, personal property, and so on. As well as specified acts regarding community and separate property. Who gets to drive the car, who's going to pay this bill or that bill. As well as orders to prohibit changing insurance at all. And always there's an order that the restrained person is not allowed to possess firearms or ammunition during the period of the restraining order. The temporary orders. But what kind of orders are available after hearing? Well, all of those orders that were available as temporary orders are also available after hearing, as well as orders for child support without prejudice, spousal support without prejudice, restitution to the petitioner for loss of earnings or out-of-pocket costs, to the respondent for costs associated with the case if the respondent prevails at the hearing, to an agency for costs of services that were provided to the petitioner, but no restitution for pain and suffering. Orders for a batterer intervention program. Orders for attorney's fees and costs. Those are orders available, as well as transferring the billing responsibility for and the rights to a cell phone. So how long do these orders last? Well, the temporary restraining order lasts 21 days or 25 days if the court finds good cause to extend it to 25 days. The orders for custody, visitation, and support survive the termination of the temporary restraining order. After a hearing, which is typically going to be 3 weeks down the road, 21 days, an order can be made that is not more than 5 years for protective orders and firearms. Custody, visitation, support orders survive the expiration of the domestic violence restraining order. If the order doesn't specify how long it lasts 3 years. And then it can be renewed for 5 years or permanently if filed within 3 months before the expiration of the order after hearing. Now, if the order is denied, the court has to provide a brief statement of reasons for the decision in writing or on the record. Let's talk about due process. Notice of the TRO is given by personal service at least 5 days before the hearing. The respondent then may file a response to the request or a denial of the allegations at least 2 days before the hearing, and those are calendar days, not court days. And when the person comes back to ask to renew an order after hearing, that is served by personal service at least 5 days before the hearing. A continuance is allowed. The respondent is entitled to one continuance upon request for a reasonable time to respond, and either party can get a continuance for good cause if they make the request in writing before the hearing or orally at the hearing or even on the court's own motion. Well, that's domestic violence restraining orders. A second kind of order that you probably need to know about is a civil harassment order that you can read about in Code of Civil Procedure, section 527.6. Most of these restraining orders are going to look a lot alike in terms of the kind of orders available temporary orders, permanent orders, things like that, but the burdens of proof are greatly different. For example, the burden of proof for a temporary restraining order in civil harassment is reasonable proof, just like in a DV protective order, temporary restraining order, but it's reasonable proof of harassment by the respondent and that great or irreparable harm would result to the petitioner if the order was not granted. For an order after hearing, though, where under the Domestic Violence Protection Act, the burden of proof is preponderance of evidence, in a civil harassment, the burden of proof is higher. It's called clear and convincing evidence that unlawful harassment exists. So what is harassment? Well, harassment includes unlawful violence, which is assault, battery, or stalking, not lawful self-defense or defense of others, or a credible threat of violence, which is a knowing and willful statement or course of conduct that would place a reasonable person in fear for himself or herself or for their immediate family, and that serves no legitimate purpose, or a knowing and willful course of conduct directed at a specific person that seriously alarms, annoys, or harasses that person, and that serves no legitimate purpose. So we have to ask, what is a course of conduct? Well, it is a pattern of conduct composed of a series of acts over a period of time, however short, evidencing a continuity of purpose. And the conduct has to be such as it would cause a reasonable person to suffer substantial emotional distress, and it has to actually cause the petitioner substantial emotional distress. Now, anyone can ask for a civil harassment order against anyone else. No relationship is required, and this is one of the places where civil harassment differs from domestic violence that requires a particular relationship. Again, a minor under the age of 12 needs a guardian ad litem to bring a civil harassment request, but a minor of 12 or older does not require a guardian ad litem for this or any other protective order. Who can be protected? Well, the petitioner, and in the discretion of the court and for good cause, all family or household members of the petitioner. And as far as mutual orders, the respondent may file a cross petition. Orders available under civil harassment are personal conduct orders, no contact and stay away orders, but you can't get residence exclusion orders like you can with the Domestic Violence Act. Other restraints on behavior that the court determines are necessary to effectuate the orders that it makes. Orders pertaining to pets, care, stay away, personal conduct toward the pets, not disposing of pets, things like that. And as far as firearms and ammunition, the person who's restrained cannot own or possess firearms or ammunition, and it has to relinquish the ones that he or she owns to law enforcement or sell them to a licensed gun dealer or store them with a licensed gun dealer. Also, attorney's fees and costs are available for the prevailing party. How long do they last? Well, the TRO is very much like the domestic violence temporary restraining order. It lasts for 21 calendar days or 25 days if the court finds good cause. The order after hearing, like the DV order, can't last more than 5 years, and if the order is silent, it lasts for 3 years. Again, it can be renewed, but unlike the DV, it cannot be renewed permanently. It can only be renewed for 5 years or less upon the request of the party without a showing of further harassment since the issuance of the original order, but like the DV, it has to be brought within 3 months of the date that it's going to expire. Due process is very similar. Personal service at least 5 days before the hearing. Again, that's calendar days, not court days. The respondent may file a response. If there's a request to modify or terminate, there has to be personal service at least 16 court days prior to any hearing to terminate or modify the restraining order prior to its expiration date. As far as continuances, the respondent is entitled to one continuance for a reasonable period of time to respond to the petition, and either party can get a continuance for good cause if they submit a request in writing before the hearing or they make it orally at the hearing, or if the court decides on its own motion to grant a continuance. Now, a third kind of restraining order you might need to be aware of is the workplace violence order that you can read about in CCP 527.8. The burden of proof here is, for a temporary restraining order, reasonable proof of unlawful violence or a credible threat of violence by the respondent, and great or irreparable harm would result to the employee. The order after hearing, like the civil harassment order, requires clear and convincing evidence. Now, the cause of action here is different. In this case, the employee has suffered unlawful violence or a credible threat of violence from any person that can be reasonably construed to be carried out or to have been carried out at a workplace. So the person who petitions here is the employer who files on behalf of the employee. And the employer-employee relationship is defined in Labor Code Section 350, and that's referenced in CCP 527.8B3. Who can be protected? Well, the employee can be protected, and in the discretion of the court and for good cause, the family or household members and other people employed at the workplace or other workplaces. How long do they last? Well, like the other two restraining orders, the temporary restraining order lasts 21 days or 25 if the court finds good cause. The order after hearing in this case cannot be for more than 3 years. And if it's going to be renewed, it can be renewed for not more than 3 years upon the request of the party without a showing of further violence or threat since the issuance of the original order if it's brought within 3 months of the expiration of the original order. As minors counsel, you may need to be aware of school violence orders in CCP 527.85. The burden of proof here is reasonable proof that a student has suffered a credible threat of violence made off campus and that great or irreparable harm would result to the student. The burden for an injunction, which is the permanent order, is clear and convincing evidence of a credible threat of violence off the school campus or the facility. And the person who petitions here is the chief administrative officer or designee of a private post-secondary educational institution. Who can be protected? Well, the student, an adult currently enrolled in or applying for admission to a post-secondary institution would qualify as a student for the purposes of this kind of an order. The family or household members of the student upon a showing of good cause, and other students at the campus or facility who are similarly situated upon a showing of good cause. Per 527.85A, with written consent of the student, the school official may seek the protection under this law if the student has suffered credible threat of violence from any individual and the credible threat of violence, while made off campus or off the facility, can reasonably be construed to be carried out or have been carried out at the school campus or facility, and the respondent's conduct is not allowable as legitimate labor dispute permitted by CCP 527.3, and the respondent is not engaged in any constitutionally protected activity. What orders can be made available? Well, the temporary restraining order, personal conduct orders can be included, stay-away orders can be included, other restraints to effectuate the court's orders. As always, the firearms prohibition automatically attaches. The person restrained cannot own or possess firearms, and they have to relinquish the ones that they may have already. For the permanent order or injunction, all temporary restraining orders can be added. The duration of the order, the temporary restraining order, again, lasts 21 days or 25 days if there's a showing of good cause. The injunction can last up to 3 years, and if it's silent, it will last 3 years. It can be renewed for not more than 3 years upon the request of a party without showing of further violence or threats, and can be brought at any time within 3 months before the expiration of the order. Due process is effectuated this way. Orders can be issued ex parte pursuant to CCP 527. The temporary restraining order has to be served at least 5 days before the hearing. A continuance, as always, the respondent is entitled to one continuance for a reasonable time. Either party can get a continuance for good cause. And as far as modifications, the person who seeks the modification must have the other person served at least 16 days in advance of the hearing to terminate or modify the restraining order prior to the expiration date of the restraining order, although the protected party may waive notice of that. Now, another kind of restraining order you probably want to be aware of, even though it's originally asked for by law enforcement, is the gun violence restraining order. Now, the statutes are found in the Penal Code, but the process to obtain a gun violence restraining order is a civil proceeding, and it's defined in Penal Code Section 18100 et sec. The burden of proof for a temporary emergency gun violence restraining order is reasonable cause to believe that an immediate and present danger that the restrained party will hurt him or herself or someone else with a firearm, and that less restrictive measures have been ineffective or are inadequate or inappropriate. For a TRO, there has to be a substantial likelihood that the restrained party poses a significant danger of hurting him or herself or others with a firearm, and that a TRO is necessary because less restrictive alternatives are ineffective or inadequate or inappropriate. For an order after hearing, there has to be clear and convincing evidence that the restrained party poses a significant danger in the near future of hurting himself or others with a firearm, and the TRO is necessary because less restrictive alternatives are ineffective or are inadequate or inappropriate. So how do you petition for this? Well, to get an EPO, law enforcement is the only one who can ask for an emergency gun violence protective order. And they can make it as a written or oral petition. For a TRO, law enforcement or immediate family can do a written petition to request a gun violence restraining order. For an order after hearing, law enforcement or immediate family can make the written petition. An EPO for a temporary emergency gun violence restraining order lasts 21 calendar days, and there is no procedure for extending or making it permanent. The TRO is 21 calendar days, and the hearing has to be held within 21 days. For an order after hearing, 1 year is the duration. Factors the court has to consider are things like recent threats of violence toward oneself or others, violation of an EPO that was issued under the Family Code, or a violation of a civil harassment, elder abuse, or DV restraining order, conviction for possession of a firearm post-conviction, a pattern of violent acts or threats in the last year to self or others, or other evidence of increased risk for violence, for example, brandishing a firearm, a prior felony arrest, restraining order violations, drug offenses, things like that. What orders can you get? Well, you can get an order prohibiting and enjoining a person from having custody or control of, or owning, or purchasing, or possessing, or receiving any firearms or ammunition. You can't get a stay-away order, you can't get personal conduct orders, you can't get move-out orders. You can get orders to surrender firearms and ammunition immediately to the requesting officer or within 24 hours of service, and filing a proof that you've done so within 48 hours. Due process. The code is silent regarding what kind of notice is due. For termination, the restrained party can request an early expiration of the order. If there is no longer clear and convincing evidence, the court then shall terminate the order. For renewal, it can be renewed not more than 1 year upon request of law enforcement or a family member at any time within 3 months of the expiration. Now, because you're working with children, you probably need to know about juvenile dependency and delinquency. For a TRO, If it's related to domestic violence, what has to be shown is a reasonable proof of a past act or acts of abuse. If it's not related to domestic violence, there has to be a reasonable proof of harassment or unlawful violence or a credible threat of violence, and that great or irreparable harm would result to the petitioner if the order is not granted. For an order after hearing, if it's related to domestic violence, the burden of proof is preponderance of evidence. If it's not related to domestic violence, the burden of proof is clear and convincing evidence. So basically what you've got here is this. The rules for domestic violence apply if it's domestic violence related. Otherwise, the rules for civil harassment apply. Well, when can a restraining order be filed? In dependency, it can be filed after a 300 petition has been filed and until the petition is dismissed or the dependency is terminated. For delinquency, it can be filed after a 601/602 petition is filed and until the petition is dismissed or the wardship is terminated. And who can petition? Well, the parent, the child, the guardian, the social worker, the probation officer, the present caregiver of the child, a court-appointed special advocate, a CASA, a representative of an Indian tribe, or someone else with an interest or relationship to the child. And who can be protected? Well, in dependency, the dependent or child subject to a 300 petition, and the juvenile court has exclusive jurisdiction for restraining orders regarding dependent children. Other children in the household, and again, the juvenile court has exclusive jurisdiction for restraining orders regarding children in the home of dependent children. The parent, the legal guardian, or current caretaker of the child, regardless of whether the child resides with them, the current or former social worker, the current or former court-appointed special advocate. These are people who can be protected in a dependency setting. Who can be protected in a delinquency setting? Well, the ward or the child subject to the 601/602 petition, other children in the household of the ward, the parent, legal guardian, or current caretaker of the child, regardless of whether the child resides with them, the current or former probation officer, the current or former court-appointed special advocate. If the restrained party is a ward or is subject to a 601/602 petition, any person the court finds to be at risk from the conduct of the child, any person with whom association with the child would be detrimental to the child. Who can be restrained? Well, in the dependency, any person can be restrained. In delinquency, any person can be restrained, or the ward or child subject to the 601/602. How long does it last? Well, an ex parte TRO lasts again 21 days or 25 if they're a good cause. An order after hearing can last up to 3 years and does not end automatically at the termination of a juvenile case. Termination and renewal. The order may be terminated by the court before the expiration date or extended by mutual consent of all parties to restraining orders, or extended by further order of the court on motion by any party to the restraining order. And violations. Willful and knowing violation is a misdemeanor punishable under Penal Code Section 273.65. What about due process? Well, a TRO may be granted ex parte, but for the hearing, personal service has to be the sooner of within 5 days the TRO was granted or 2 days before the hearing. A continuance, again, the respondent is entitled to one continuance. Either party can get a continuance on a showing of good cause. Now, you probably will not have as much occasion to be familiar with elder abuse, but that's one of the protective orders that's available in California. The purpose of an elder abuse restraining order is to prevent the recurrence of abuse. The burden of proof is reasonable proof of past act or acts of abuse, and there's no need to show that the acts will continue or repeat. The burden is preponderance of evidence. For elder abuse, you're talking about physical abuse, neglect, financial abuse, abandonment, isolation, abduction, or treatment with resulting physical harm, pain, or mental suffering. It can include deprivation of care by a custodian of goods or services necessary to avoid physical harm or mental suffering. What kind of orders can you get? Well, all the ex parte orders are available. Residence exclusion is available if the court finds that the physical or emotional harm would result to the petitioner or the family or the household member if the residence exclusion were not granted. An attachment may be issued for damages if it's financial abuse. Attorney's fees and costs are available for the prevailing party. The temporary restraining order, as always, lasts 21 days or 25 days if good cause is found, and if the matter is continued, the granted TRO remains in effect until the hearing. For an order after hearing, the order can be extended for no more than 5 years. If the order is silent on this duration, 3 years is the maximum. For due process, the ex parte may be issued pursuant to CCP 527. A TRO has to be served by personal service at least 5 days before the hearing. The respondent may file a response that explains or denies the alleged abuse. Again, the respondent is entitled to one continuance for a reasonable period of time to respond to the petition, and either party can get a continuance for good cause, as long as they make the request in writing before the hearing or orally at the hearing, or even on the court's own motion. Another kind of protective order you're probably going to be familiar with is criminal protective orders as defined in Penal Code Section 136.2. Now, the purpose and burden of proof are to protect a victim or witness in a criminal case. The burden of proof is a good cause belief that harm, intimidation, or dissuasion of a victim or witness has occurred or is likely to occur. What kind of orders are available? Well, there's personal conduct restraints. Oftentimes, criminal judges call this no negative contact orders. Stay-away orders are available. Orders that the defendant must not violate Penal Code Section 136.1, which is dissuading of witness. Any other person other than the defendant must not violate Penal Code 136.1. Witness protection. The restrained person is prohibited from taking action to locate the protected person. As far as firearms, the restrained person cannot own, possess, purchase, or receive firearms or ammunition. And the duration of this criminal protective order is until the defendant is no longer subject to the court's jurisdiction. Now, what actually happens is that there is a criminal protective order that's issued at the time of arraignment, and that protective order will last up to the specified period of time. If the case resolves prior to that time, then that order is either dissolved and replaced by a post-conviction order. So if a defendant is convicted under Penal Code Section 273.5 or of a crime of domestic violence as defined in Penal Code Section 13700, the sentencing court must consider issuing a no-contact restraining order which may be valid for up to 10 years as determined by the court. This protective order may be issued by the court whether the defendant is sentenced to state prison, county jail, or if imposition of sentence is suspended and the defendant is placed on probation. So what if you've got multiple orders of various types? What then? Well, here's how they stack up as far as priorities of enforcement. And you can find this in Penal Code Section 136.2 C and E. Emergency protective orders always prevail if they're more restrictive and they pertain to the same parties. Any no-contact provision in any restraining order, whether it's criminal or civil, a criminal protective order, and the most recent civil order. And that's the priorities for enforcement. Well, that's probably more than you ever wanted to know about California protective orders, but hopefully this primer and the handout will give you enough information so that you know in the various circumstances that you relate to kids with and the court with, which kind of protective order is necessary, how to go about getting it, and how to go about renewing it. Thanks for your participation.